Record, same appearances as previously noted. Ms. Landgraf?
Thank you, Your Honor. The evidence was lacking for Act 79 search. There was no evidence that the probation agent was contacted either before or after the search, which is a requirement. Also, although there was testimony that he was on probation, there was no evidence on what he was on probation for. It must be a felony offense or under certain misdemeanor chapters. None of that was testified to. So I think the state's argument fails. And
well, that's easy to cure. It can be, he can motion right now to reopen. Court can say, yep, he can go and get it on. And that one's easy to cure. Anything else?
no.
All right. I'm going to guess you're going to ask the motion to reopen.
I could, but I'm actually confident he did testify it was felony drugs.
And I don't know at this time. Ms. Burhow is an amazing court reporter, but I don't get to have real time when I have somebody who is not in my courtroom. Usually I have real time. So I don't know. I knew, and I can just say, I know what Mr. Akana is on probation for. I'm the one that sentenced him and sent him to prison. So I'm well aware of that, but you may be confident, Mr. Schmidt, but I don't know. So if you would like to, if you are going to ask to reopen, I don't know, because that probably could have went right over my head because I know I sent him to prison. So
I'll just call the officer then if the court doesn't
all
remember
right.
either.
Deputy Mangan, you are still under oath. Please come forward. Just have a seat. Mr. Schmidt.
Prior to going to the Akana Kurkowski residence, did you call DOC?
I did not.
How did you confirm the supervision status?
During those checks that I testified to, one of those returns that we get when we run a check of somebody is a DOC return. That DOC returns, the DOC return provides information on demographics of the probationer, as well as address, date of birth, those such things, as well as the offenses that they're on supervision for. The offenses that Mr. Akana was on supervision for were felony level drug offenses.
Okay, and that's also the same return that said where he lived.
Yes, his address is on that return as well.
Okay, that's all.
All right. Any questions?
No.
You may step down. Thank you. Any further argument, Ms. Landgraf?
No further argument, Your Honor. I was provided with some of this additional information. Part of my motion was that I didn't have any information about why the Act 79 search was done. And I did get a report from the DA's office on Friday emailed to me. It was heavily redacted.
I'm going to guess that would be the information source. Or source of information.
I actually don't have the source of information, and I don't think my client's entitled to that because that's not her accuser. That is Eddie's accuser. So I know that we're not entitled to that, but I did want to inform the court. Like I did get additional information on Friday, but
it was last minute. Yeah. Before this. So I understand. Okay. Any rebuttal?
No rebuttal, just I apologize for getting that to you last minute. I knew what the content of the information was, but I didn't know until last week there was a written version of it. So that's why I tried to get it to you as soon as I got it.
All right. Okay, well, I have heard the testimony of Deputy Mangan here today. And Ms. Landgraf, even though I was aware why Mr. Akana went to prison, I sentenced him. I still can't rely upon that, like you said, and unless it is verified through a source, or perhaps I could have taken judicial notice of that fact, but I didn't need to. Under case law, anyone can ask to have a suppression hearing reopened, even a day or so after the suppression hearing. The courts did allow Mr. Schmidt to continue to question Deputy Mangan. The court did receive a lot of information regarding that search and what led to the desire to perform that search. We are using a source of information I guess not necessarily a confidential informant, or it's not with Ms. Kurkowski, it's a source of information. And here the source of information, as testified by Deputy Mangan, has proven to be reliable in the past, that there was a basis of knowledge of that source of information, personal knowledge, that individual was present at that time of the alleged sale of the firearm between Mr. Akana, Hawaiian Eddie, and this other guy, Nelson. There was much specificity as well as detail provided regarding that day, that time, that place, and who was there and what exactly happened and all of those things. And so when reviewing a source of information, the court has to look at the multiple factors to determine the totality of the circumstance here. And it, in that basis and in that review, the court does find that there is enough to find reasonable suspicion as it relates to any alleged crime that may have been committed, was committed, or is about to be committed. And in further, as it relates to an Act 79 issue, that in Act 79 is stated by Mr. Schmidt, with U.S. Supreme Court cases, and then an older Wisconsin case as it relates to parolees, that there is such a reduction and lesser degree of constitutional rights as it relates to probationers. Therefore, that would give the ability for Deputy Mangan to be able to do a search. Mr. Akana stated he lived at that residence. Ms. Kurkowski stated that she lived at that residence. There was testimony from the deputy that that bedroom in some way marked and identified that it was Mr. Akana and Ms. Kurkowski's bedroom. So they did share that bedroom. Ms. Kurkowski did walk Deputy Mangan through the home to the bedroom in which the drug paraphernalia was visually seen by the law enforcement officer, which did give further ability to seek a search warrant, as there was a belief that with at least the drug paraphernalia that there could be a potential to have illegal substances in the home. Therefore, based upon all of that information, there was sufficient evidence to, there was enough reasonable suspicion to do an Act 79 based upon the information, and there was sufficient evidence included in the search warrant to have the search warrant granted. Therefore, the court is going to deny the motion for suppression. Anything further on the record?
Not from the state.
No, Your Honor.
Let's get a date and time.
We do have an offer that I believe is reasonable that I'll discuss with my client in more detail.
It's reasonable, so would you like to set something that could be a potential plea and sentencing? And I'm asking that right now just because my summer is so jam-packed
Yes.
with court cases. And if we set it for status, likely it's not going to be until fall.
Yes.
I could do, it's on an ADA week because again, this is a lot. I could do July 23rd at 10, and that's right after our CJCC meeting, Mr. Schmidt.
That should be fine.
Does that work for you, Ms. Landgraf?
So that's next week. So
Otherwise, the next available date would be August 25th at 9:45.
you have a preference if you want to do it next week or do you want to do it in August? Yeah, my client's already scheduled to work next week, so if we could have that August 25th date.
August 25th at 9:45. All right. Well, actually, I'm not sure how long this would take, but could you do 9:30? Because I have an initial appearance on that date and time, but it's most likely going to go away from a deferred program.
Yes.
All right, so 9:30 on August 25th. So just block it that whole half an hour because then we have that competency hearing. All right, thank you. We will see you then. You can come up here and get your notice. Ms. Burhow, I'm going to log off and then log back on around